Hello students, my name is Liz Attia and today's topic is negligence. Okay, so the law of negligence. In terms, I guess, of the elements of negligence, there are four main elements for a successful cause of action in negligence. The first is that the defendant owed a duty of care to the plaintiff, that the defendant breached that duty of care, that as a result of that breach, the plaintiff suffered damage, and that the damage was directly attributable to the breach. So that actually goes to causation. The relationship between doctor and patient and hospital and patient has long been recognised in the law of negligence, and the same principles apply to other health professionals. And the four elements, as I mentioned, where the duty is established, that there's a breach of that duty, that there's damage as a result of that breach, and causation are the four elements that need to be substantiated. But their application is not always straightforward. Let's talk about that a little bit further. So, duty of care. What's the duty when there's no existing relationship? It's quite clear when the health professional is actually in a business or a centre, it's within working hours, they're in a uniform, and a patient or a client actually comes to see them within that context. But what actually does the law say about a duty of care when there's no existing relationship? Well, in fact, this particular question was considered in the New South Wales Supreme Court in the case of Lowndes and Woods in 1996, where in fact a doctor was found to be negligent in failing to attend an emergency. And I'll refer you to page 143 of the textbook for a full citation of the case and the findings of that case. In summary, as a general rule, the law doesn't impose liability on individuals for failing to assist. However, the courts have been willing to oppose a duty on a defendant when positive steps have actually been taken and additional factors are present. So if the plaintiff caused the damage, or if the patient is the usual client of the health professional, if they're known to the health professional and they're asked to help, if they're identified as actually being a health professional and they refuse to help, then the courts in those circumstances will actually impose a duty. And the reason why is because the courts will actually say, well, as a health professional, you are in a position of trust within the community. And so as a community obligation would be expected to render assistance in those circumstances. So again, go back and have a look at that particular case as it informs our understanding of what a duty of care is. But having established that a duty of care is owed, the next is to establish whether there's been a breach of that duty. And this was considered in the Rogers and Whittaker case of 1992 in a majority decision. And it's in turning its mind to considering the question of breach of duty, the court in fact considers a number of factors. Once again, I'll refer you back to the textbook. It's on page 148 of the textbook for a full consideration of the findings of the court and some of the deliberations of the circumstances the court turned its mind to. It's not always straightforward whether in fact there has been a breach, but do note and take into mind that a breach of duty can actually be by action or inaction, and both will equally constitute a breach in the eyes of the court. In the case of Rogers and Whittaker, it was a situation where Rogers actually had an eye condition which rendered one eye unusable to the point of near blindness, and she was going in for a procedure on her good eye, so to speak. And in that particular case, the doctor failed to advise her of the risk of sympathetic ophthalmology, where if something were to go wrong on the eye that was being operated, there might well be a consequence to her good eye. And in that situation, the court actually found that a failure to inform her of that risk, although it was a 1 in 14,000 chance of sympathetic ophthalmia actually happening, it was considered a breach of duty because of the significant implications it would have on her lifestyle and her ability for independence through vision. So in assessing whether there has been a breach of duty of care, there are two main principles which might be adopted. There's the Boland principle, which is where a body of expert witnesses who belong to the profession will actually attest as to the conduct of what a proper and reasonable body of peers within that profession would consider reasonable. And this principle is derived from the English case. It's quite influential in England. So it's the duty and whether a breach of duty is established by health professionals within that particular profession, and they attest to what's reasonable in the circumstances. In Australia, however, we've adopted for a more subjective standard, and that standard is defined as by the courts. And as I mentioned in the Australian case of Rogers and Whittaker, the court decided that in her particular situation, in Rogers' particular situation, she would have needed to know of the risk of 1 in 14,000 because of the grave implications for her. So it's a subjective standard and it's on a case-by-case basis. So in fact, in Australia, the Boland principle has been discarded, and instead we've adopted the subjective standards, and the courts adjudicate as to what is the appropriate standard of care after giving weight to the consideration of what that person in those circumstances would have needed to know and what the health professionals did or didn't do. So as you can see, it's actually in fact a higher standard than the Boland principle, because it's not about what's reasonable by a body of peers, but it's about what's reasonable in those particular circumstances based on the particulars and the facts of the situation as is presented. So the legal standards for adequate disclosure, the Boland test is in the UK and Australia to a certain degree, but we also have the subjective person standard, which is the patient standard. And as I mentioned in the Rogers and Whittaker case, the 1 in 14 chance of complication because of the procedure, and she only had sight in the one eye. So the disclosure needed to be patient-focused given the circumstances. Okay, the third element of negligence, as I mentioned, is the damage. So there might well be a duty of care and there might be a breach of duty, but no action can be brought in negligence if there's no damage which is sustained or suffered by the plaintiff. So damage is clearly a major consideration in negligence claims. The other element of negligence, which I'll draw your attention to, is this idea of causation. And that's more difficult to prove, and there's not a lot of literature on it. However, all I'll need to actually say in respect to causation is that given health professionals and their role in assisting people with health complications and the vulnerability of the health status that patients and clients are often in, the breach of duty must be attributed solely, the damage must be attributed solely to the breach of duty. It can't be some other extraneous factor or complication which wasn't actually as a result of the breach. So, for example, if there is a complication which arises in the course of providing medical intervention, even though there was a breach, if that damage wasn't as a result of the breach but as a result of some other factor, then it would not be considered to be negligence. And we'll talk a little bit more about this when we actually go to contributory negligence, which we'll talk about in a few lectures' time. Okay, thank you. Thank you, students. That brings today's topic to an end.